Well, good morning and welcome all of those of you that are joining at the moment. We can see people are just joining at the moment. Very good to see so many familiar names with us here this morning. My name is Tom Cosgrove, KC, and I have Ruchi Parekh joining me at the moment to talk about a case. We were tempted to start off this seminar by giving you this lovely view of the Snowdonia National Park and jumping on the bandwagon and talking about the hillside case, which everyone else seems to be talking about for the last week. But don't worry, we're not going to do that. We're going to have our own case to talk about here, and we're going to talk about the Court of Appeal case of Thurston and Mid-Suffolk and Bloor homes, what are called the Thurston case, which the Court of Appeal gave judgment on the 28th of October, so very recently. Ruchi and I were counsel for the first appellant, Mid-Suffolk District Council, and you can see also represented were Bloor homes with my great friend Paul Tucker, and Merrick Lewis acted for the parish, who were the claimant in the High Court. It is the latest case in the planning sphere to discuss the key distinction between the construction or interpretation of policy and the application of planning policy. And as I suspect nearly all of you on this webinar are aware, that distinction is critical for decision making. Understanding the difference is fundamental, for example, to insulating a decision from challenge and to making suitable arguments at the application stage, for example, in support of a proposal. And I'll return to that theme in a moment. Just by a way of overview, what we're going to do in this webinar, we probably won't take up the full hour, you'll be pleased to hear. We'll probably aim for about 40 minutes. We're going to start off with a few words from me about the context for application versus interpretation as concepts. And we're going to look then with Ruchi at some of the particular facts and the nature of the case, both in the High Court and the Court of Appeal. And then we're going to look at some practical implications together from the Court of Appeal judgment. And finally, take any questions. We've had a few questions submitted to us before, so thank you for that. We'll seek to address those and any others that we can. There is a Q&A function that's been enabled, so if you want to ask any particular questions, please do. So if we just start off by just refreshing our memories, perhaps on some basic concepts, just to tee up what the Court of Appeal we're dealing with. The distinction between the application of planning policy and interpretation of planning policy, it's important to note from the outset, is one which applies with equal force both to development plan policies, which is what the Court of Appeal concerned with in the Thurston case, but also to national policy and, for example, the NPPF and other government policies. So it is an important distinction and important concepts that apply throughout. And it all really, I think, stems back from March of 2012, nearly 10 years ago now, in the seminal case of Tesco and Dundee, which you'll all be familiar with, where Lord Reed made clear that the interpretation of policy was a matter of law. But once a decision maker had understood the meaning of a policy, the application of those policies was a matter for the decision maker alone, subject, of course, to the usual challenges of irrationality under public law principles. It was a seminal moment because it made clear that there could only really be one true meaning of a given planning policy. But any hopes that there might have been in the planning world, or the judicial world at least, that would give rise to some clarity and less litigation, as we all know, has proved unfounded. And that is because the distinction between application and construction is not always an easy one for people to make. Moreover, the concept of planning policy construction, we're told by the courts, requires a contextual approach. And so when you're interpreting a planning policy, you don't apply the same principles the courts say as you do when you're interpreting a contract or a planning permission. No, you have to look at the context, and the context is an open-ended concept. Perhaps the best example of how difficult it is the well-known Hopkins-Holmes litigation, which went all the way up to the Supreme Court, culminating in 2017, where there were at least 3 competing interpretations or constructions of para 49 of the NPPF as it then was. And the Court of Appeal disagreed with the High Court, and the Supreme Court disagreed with the Court of Appeal, all very experienced judges and you would have thought experts in construction. And there then followed a series of cases in the following years where policy interpretation was really at the heart of the issue and the cause of the litigation. And the Court of Appeal, or for present purposes, Judge Judy, regularly expressed despair at what they call the excessive legalism that was being pursued in such construction arguments. And it's right to say that those distinctions between policies and the interpretations put forward are sometimes hard to distinguish. Many of you will be familiar with the Court of Appeal cases of Canterbury and Chichester in the last few years, which relied on context to formulate a construction of particular development plan policies. And it's quite hard to distinguish them, I think. All good news for lawyers, but bad news for an efficient planning system. But we think that we've begun to see a shift in approach, and we think the Thurston case is the latest and quite an important example of that shift in approach. And the shift, I think, is certainly at the Court of Appeal level, is having judges inhabiting the Court of Appeal being prepared, if at all possible, to find that an approach to policy, whether that be a national or development plan policy, might in truth really be one of application and judgment rather than one of construction. There have been a number of cases in that front. An important one from 2021 last year was a case called Asda and Leeds City Council. And in that, Lord Justice Limblom in particular said, and that was a case about the MPPF, he said the courts will seek, and I quote from para 35, to look for a straightforward interpretation of policy. Often a court will be entitled to say the policy simply means what it says, and the job of the decision maker is to apply it with realism and good sense in the circumstances as they arise. And the emphasis there was on applying a policy with realism and good sense, rather than getting tied up in legalistic arguments. Now, I'm going to hand over, I think, to Ruchi to talk about some of the particular facts in Thurston, and then we'll come back and look at some practical implications and some concepts.
Great, thanks, John. Right, so I'm going to look at briefly at the background that led to the Court of Appeal decision in Thurston. And effectively what we had here was that in 2019, Bloor Homes made an application for outline planning permission in Thurston Parish Council, and the scheme was for a residential scheme for up to 210 dwellings, open space, associated infrastructure, including highway junction improvement works. And I'll come on to those in a little while again. This application then came before the Planning Committee in 2020, and as is normally the case, there was an officer report advising members as to how the application could potentially be decided. And the officer report was a super thorough 90-page, almost thesis, one might say, that took quite a lot of care and attention to grapple with a multitude of policies. Now, the officer report overall recommended that approval should be granted subject to conditions and appropriate Section 106 agreement. But just taking a step back, it went through in a lot of detail what the development plan context was. And so there's at least a few things here that are important to bear in mind when we then come on to firstly, the High Court decision and then the Court of Appeal decision. So firstly, in terms of the adopted local plan policies, the most important ones that dealt with housing, so the spatial strategy, settlement hierarchy, and the ones restricting housing development in the countryside, the officer advised that those policies had been held to be out of date in recent planning appeal decisions, and that because these were amongst the most important policies for making the decision, the paragraph 11, or the so-called tilted balance, was engaged. The next step then was to look at the neighbourhood development plan, which was up to date, firstly, and the officer in relation to this highlighted the neighbourhood plan policies that was sort of engaged by this application, and in particular, what was dealt with in huge amounts of detail was neighbourhood development plan policy 1, and that required new housing to be focused within the settlement boundary. Now, I won't say more about this because John's going to talk about it at great length. But that's where we had the sort of the development plan sit side by side, and the local plan and the neighbourhood development plan. But of course, beyond that, there were other things happening on the ground. So we had at that stage the joint local plan that Mid-Suffolk was progressing. At the time of the application, this was at Regulation 18 stage, and the officer advised effectively that because it was still in the sort of, in this not quite there effectively, it naturally afforded limited weight, but it did provide a helpful indication of the direction of travel for where sustainable development might be placed during the plan period. And this was particularly relevant because the site, the development site itself, was in fact allocated in the joint local plan. And then another piece of the puzzle is that during the course of the joint local plan process, the council naturally had an up-to-date identified housing, up-to-date housing figures effectively. And on those figures, the minimum housing requirement for Thurston Parish Council was just short of about 1,500 homes. And this was for the whole plan period up to 2036. And in particular, the council, the Suffolk Council advised, sort of the office advised that even though just prior to this application being considered, 5 large schemes had been granted planning permission in Thurston, but even if you accounted for all of those, you were still left with a shortfall of around 650 dwellings. And so that was an important sort of contextual point to take into account when you're looking at the overall scheme. And so, it's as I say, it's a 90-page report. The officer grappled with all of these and then naturally reached the conclusion that actually there was a complex interplay of material planning policies here. And no doubt, not the first planning officer to grapple with the sort of different directions in which development plan policies inevitably pull. But he looked at all of that, and then the conclusions that he reached was that, well, first of all, there was a conflict with the development plan overall, and that was because the housing settlement policies of the adopted local plan were breached by this development being in the countryside. But then he went on to look at the second stage of that section 38.6 test and said, well, actually, the material considerations overwhelmingly favour the grant of permission. And in looking at the material considerations, a lot of focus was placed on those highway junction improvement works, because in fact, no developer had been able to achieve those works, which was seen as crucial to the sort of future development of Thurston Parish. And also the highway authority itself had said that they didn't control enough land, they couldn't actually just deliver those works. So this was seen as a benefit that in and of itself would have been weighty enough to outweigh the conflict. But in fact, there were a whole raft of other benefits that were associated with this scheme. And then what's quite relevant for the challenge is that while all of this was the overall conclusion, in terms of the neighbourhood development plan policy, what the officer advised was that there was naturally a tension with that policy one, which required development to be focused within the settlement boundary. But while there was a tension, there was no conflict. And it's that piece of advice really that kind of took centre stage as the decision was challenged. And so it was challenged in the High Court by the Parish Council on 3 grounds. And the first ground, which was really the focus in the Court of Appeal, was that members had been wrongly advised on the Neighbourhood Development Plan Policy 1 because they were not advised that there was a conflict. There were also 2 further grounds of challenge, one to do with the members being wrongly advised again on paragraph 11 and paragraph 14 of the NPPF. And this was the way in which officers had advised effectively that the tilted balance was engaged. And then there was the third ground of challenge, which is that because this was such a large scheme, well, that's what the Parish Council was saying, was that if you were going to grant permission at this early stage of the local plan process, then you were going to prejudice the ongoing local plan decision-making process. Now, the High Court judge was Mr. Dimmold KC, who sits as a Deputy High Court judge and is an extremely experienced planning silk and has been doing this for years. And his view and his overall conclusions was that actually the Parish Council's complaints were sort of well-founded. He found that members had been materially misled because in fact they should have been told that there was a conflict with policy 1, and that if you look at policy 1, and think about, approach it in the way that all the cases tell you to approach it in terms of interpretation. So he looked at the Canterbury and Chichester cases, and he said, well, following Canterbury, really, you should have looked at the word, you should have looked at context, and Mr. de Mol Kathy's view effectively was that there was a conflict, and that therefore that was a fatal legal error. Under ground 2, he also agreed that the tilted balance was flawed, but that also flowed from his conclusion that that was because members weren't properly told about how policy 1 was to be construed, and therefore any sort of knock-on decision that you took about the tilted balance or any other planning judgment that was necessarily vitiated by the fact that you didn't properly understand what policy 1 was talking about. And then ground 3 was dismissed. Say both Mid-Suffolk District Council and Bloor Homes appealed the High Court decision. This went to the Court of Appeal, and really by the time we got to the Court of Appeal, the only real point in issue was this neighbourhood development plan policy 1, and the Court of Appeal said that Mr. Mulcahy got the decision wrong. And I'm going to hand back to John now to explain a bit more about the Court of Appeal decision.
Yeah, thanks, Ruchi. So, as you will have discerned from Ruchi's description, there were lots of moving parts and lots of arguments being run in the High Court. But by the time we got to the Court of Appeal before Lord Justices Singh, Lewison and Whipple, we really had focused it down to focusing on policy 1, which you see in its full glory there, with lots of constituent parts. There were many submissions about how those constituent parts related to each other. For those real planning nerds amongst you, I suspect in the nicest possible way, there may be a few. The case was actually live streamed, so if you're really lacking in sleep, you can go and watch us on YouTube battling with our opponents and the judges. They were quite interventionist, as you'd hope, from the Court of Appeal. Be that as it may, the focus then became really policy 1, part A, which we've set out there. And as you've heard, this proposal in issue was outside of the settlement boundary, albeit still within the parish. And the officers had reported in their very thorough report that there was, as they put it, a tension, the phrase they use, a tension with that policy, but no conflict. Although, as Ruchi has explained, they did accept there was a conflict with the plan as a whole, the core strategy and so forth, much of which was out of date. Now, Tim Mould, as Ruchi said, an incredibly experienced planning judge and practitioner, sitting as a deputy in the High Court, found that the committee members were materially misled. And he did so because he felt that the officers, in concluding there'd been no conflict with that part of the policy, had materially misled the members. It was a classic, if you like, construction argument. He considered that the only proper construction or focus meant in context that there would be a conflict with it if you put a development outside of the settlement boundary. Now, the Court of Appeal totally disagreed with Tim Mould on that point and felt he'd got it wrong as a matter of approach. And I think this is the nub of the point I was making earlier about perhaps a practical shift in the Court of Appeal as to how we should perhaps deal with some of these policy arguments. What the Court of Appeal explained, and Lord Justice Singh gave the lead judgment, was that this was really, in essence, a case about the application of a policy rather than the construction of it. Policy 1, Part A, is a typical kind of policy I suspect many of you will have seen in development plans up and down the country. But the Court of Appeal felt that this judge and the High Court had fell into error by confusing the concepts of application and construction or interpretation. Quite a bold thing for the Court of Appeal to say, you may think, in relation to a very experienced judge. But in simple terms, what Lord Justice Singh said, well, why are we arguing about the construction in this case? The word focused in Part A of Policy 1, obviously, he said, obviously doesn't mean that there can never be any development of a general kind outside of a settlement boundary. As a matter of simple textual analysis, focused doesn't preclude absolutely anything. So he felt it was really then a judgment for the council as to whether in the particular circumstances there was a conflict with the policy or not, subject to irrationality and so forth. It was a matter of application rather than legalistic construction. The officers had said tension but no conflict, and Lord Justice Singh felt that they were entitled to do so. In fact, he felt that that was, as he put it in paragraph 56 of his judgment, a, quote, reasonable application of the policy. So what messages do we take from that rather stark position, which differed from the High Court in terms of this debate about construction and application? Well, I think there are 3 points I would initially make before I hand over to Ruchi. And the first general one is this, that the court really has re-emphasised again in this context and these kind of cases that they will try and make sure there is a benevolent approach to decision making. That comes, of course, inevitably with certain caveats. You've got to do, as a decision maker, you've got to do the basics. You've got to make sure your decision is relatively clear. So, for example, it's pretty well understood now, the Court of Appeal emphasises again, that you've got to reach a clear conclusion as a decision maker on whether there was compliance with the development plan as a whole or not. But beyond that, provided you've considered relevant matters, it seems to me the courts, and this is a good example, that will seek to take a benevolent view of decision makers, whether they be inspectors or authors of committee reports, and in doing so seek to avoid and step away from legalistic arguments about the construction and interpretation of planning policies, if at all possible. There will, of course, be cases where there isn't a proper debate to be had about that. But in those blurry areas, I think where a few years ago, courts would be at the Court of Appeal level more prepared to engage in construction arguments. I think where we are now in a series of cases, there's a more recent case in July called Wyatt as well. And I think a stark example in Thurston is that the courts are saying we really need to treat these more as application and judgment matters rather than ones of construction. So that's the first point, I think, a benevolent approach, providing you do the basics correctly. The second point, which follows on from that, is I think we are in a position where we are getting as near as one can to the constraints of Tesco and Dundee, because obviously we have a Supreme Court judgment which indicates that policies, there's only one true meaning of planning policy. And so if you adopt a construction of policy that's wrong, there will be on the face of it an error of law, which may or may not lead to a quashing of a decision, depending on the implications of the error. But I think we're getting, with these recent cases, and again, I think Thurston is an important example of that, as near as one can, the Court of Appeal pushing the boundaries of Tesco to try and steer the way planning cases are framed away from legalistic construction issues to matters of policy application and judgment, if they possibly can. The final point I think I'd make was that practically, when you're considering as an applicant or as a local authority, what this means for you in terms of your development you're promoting or your decision you're taking as a council, it is critical that you consider, when you've identified the relevant development plan policies, whether you can in fact frame your decision or frame the application you're making as one really as a matter of application and judgment and common sense and realism, rather than a legalistic point about the particular wording in a planning policy. Seemingly easy to say that, but I think it does require a bit of thought and care. From a decision maker's point of view, if you can do that properly, you have a much better chance, it seems to me, of insulating a decision from challenge. And that will also be something from a developer or applicant's point of view, when you're making an application, or as was the case here with Bloor Homes and the parish and the council, the local planning authority, in seeking to get what was considered to be an important and sustainable development through the planning system, to try and frame your case in a way that emphasises the nature of the policy being one of application, rather than teeing up in a report or in a planning statement a construction argument, which in a sense may give something a potential claim into the judicial review or a section 288 challenge for an inspector's decision, something to hang a peg on. So I think that's the important takeaway from Thurston. It'll be really interesting to see whether there are more cases coming this way which really emphasize this. Lord Justice Lindblom has been almost doing a one-man crusade on this for the past few years. So it's quite nice in a way that we have a differently constituted Court of Appeal, particularly with Lord Justice Singh and Lewis. Lord Justice Singh is a very experienced public lawyer who's done a lot of planning cases, really emphasising this approach in the planning sphere. But Ruchi, you're going to talk about perhaps some other practical points.
Yes, thanks, John. So this really flows on actually from what the sort of the overarching themes that John mentioned. But I thought we could just run through some quick examples of how this might play out in practice. So obviously, as we know, the first point is that, you know, if it's a matter of interpretation is a pure question of law, and that's when the courts will get involved. But I think what we're seeing, and as Tom has said, is that there is a tendency and a trend now to restrict what is a question of law. So they're trying, you know, the Court of Appeal certainly has tried to narrow that down, sort of to get it as, you know, as narrow as possible, so that not every decision is being challenged. And a good example of that is actually, you know, the term settlement boundary. And in fact, this was an example used by Lord Justice Singh in the judgment as well, because what he was saying was, well, you know, if what the local planning authority had done was they had said, oh, well, this is within the settlement boundary, then that would obviously be an incorrect interpretation, because you know what the settlement boundary is. It's a defined area, and whether something's inside or outside of it is a sort of a thing that if you got wrong, then that would be a question of interpretation which the court would intervene with. But as you can tell, the question of settlement boundary is quite narrow within the whole, you know, within the overarching policy, and that's the only bit that Lord Justice Singh kind of picked out and said, well, you couldn't get that wrong as a matter of fact, because that would be a legal error, but everything else that flowed from the policy was actually about judgment. And so that's the next question, which is, you know, at what stage are you away from it being a question of law, and are you within the territory of planning judgment? And as far as we can tell from looking at the line of cases that has led up to Thurston, is that the courts are super keen to keep that as broad and as open as possible. And where there is any scope for planning judgment, then the courts seem to be emphasizing, at least at the appellate level, that this is not a question of interpretation, but it's a question of planning judgment and a question of application. And I think the word focus here is a good example. You know, John's mentioned this is, you know, it's not an unusual word that just features in this neighbourhood development plan. It appears in different local and neighbourhood development plans across the country. I'm obviously not saying that focus is always going to be a question of judgment, because you do have to look at context. But this is a good case in which you can see why it is a question of judgment. And one of the arguments when we were in the Court of Appeal, one of the arguments that we were presenting was that, well, you know, let's think about practically what focus means, because again, as Tom said, focus obviously doesn't mean that you could never have something outside the settlement boundary. So you even the starting point is that there must be a bit of judgment involved. But when you take that further, you can see why in different cases you would reach different answers about whether something's been reached or not. So for example, if you've got a scheme of, as we were saying here, 200 homes outside the settlement boundary, but all your other housing was within the settlement boundary, and that's a much larger, greater number, then in those circumstances, a planning officer is quite entitled to reach the conclusion that the housing in the village is still focused within the settlement boundary, notwithstanding that there is a 200 home scheme outside. But obviously, if you were looking at a different scheme, and say if you had like a 1300 home scheme, which again could happen, in those circumstances, an officer could obviously reach a completely different conclusion and say, hang on, this, you know, take a step back. Actually, we've now got to a stage where there's such a large scheme or such a number of large schemes outside the settlement boundary that we can no longer honestly say that housing is being focused within the settlement boundary. And so therefore, you would say that the policy had been breached. But it all comes down to sort of that application of policy and the application of planning judgment. And that's something, as you know, as we keep saying, the courts just don't seem to want to interfere with. So yeah, I know I've only focused on the two words that appear in this policy, but hopefully that gives you a sense of the sort of scope for planning judgment in these kinds of cases. The final thing I then wanted to talk about, which is sort of straying away a little bit from interpretation, and versus application. But I think it's worthwhile just pointing out about this question about misleading the committee, because obviously the test to be successful in judicial reviews of this kind is you have to show that the officer report materially misled the committee. And so this is quite a good example where Lord Justice Singh again just sort of re-emphasizes, because the courts do this all the time, but when you're bringing a challenge, just you have to think about context, and you can't just like make these arguments in the abstract. So the example here is that the parish council had submitted that it was not enough for the council to have been advised that there was a conflict with the development plan as a whole, because that is what they were advised, but rather what the officer should have advised also was that you go through each individual policy and identify whether or not there's a conflict or not. And here, if he should have gone through the neighbourhood development plan policy 1, identified specifically that there was a conflict, and then weighed that into the balance. And the Court of Appeal was quite kind of strong on this, where they said, well, hang on, you can't just look at these things in the abstract. What are we actually talking about? We're talking about a situation where the committee has been advised in clear terms that this is development in the countryside, and therefore conflicts with the adopted local plan housing policies that talk about spatial strategy and housing not being in the countryside, basically. And then the parish council, you're trying to construct a whole argument around a neighbourhood development plan policy that sort of is, has the same aim. And so it's not really the kind of challenge that you should be bringing, because this is not a question of material misleading. And had the challenge actually been about different things, so had, for example, if the development plan as a whole had been breached because of conflict with other policies, say to do with employment, and then you forgot to factor in neighbourhood development plan policy 1, then that's the kind of area in which you can go to a court and say, I'm aggrieved by this decision and there was a legal error and it should be quashed. But when you sort of effectively end up like nitpicking on stuff that it's clear that the committee have understood, they've obviously understood that this is in the countryside, then it's not really good enough to come along and say, well, you should have also looked at this sort of sub-part of sub-policy 1 and decided otherwise. So yeah, I think for all of those reasons, it's a good decision. It's a good decision for decision making, and I think it gives you it sort of endorses the practical challenges that planning decision makers face on the ground day in, day out, and sort of trust to them the job of application of planning policies, which is never an easy task.
Yeah. I agree. Thanks, Ruchi. And we're going to take a couple of questions. We've had some questions submitted beforehand, which many thanks. And one of them, which we thought was quite interesting, came from Kevin Scott. I don't know whether Kevin is still with us, but Kevin from Solve Planning said, do the speakers consider this judgment has any implications for the interpretation of para 14 of the NPPF, or does this fall outside the scope of the matters considered in the judgment? It concludes, he says, the officer recommendation was reasonable, but does not seem to comment on this issue specifically. Well, Kevin, thank you for that. In fact, para 14 was discussed in some detail at the High Court stage before Tim Mould KC, because it formed one of the grounds. And I mean, I'll just say 2 things about that. One, there's a couple of interesting points actually. In the High Court, it was agreed, and for those of you who can't remember, para 14 is the particular part of the NPPF dealing about presumption in the context of neighbourhood plans, and says in short that where the presumption, the para 11 presumption applies to applications involving housing, the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits, provided a number of factors apply, and the factors then listed at A to D. Tim Mould agreed with us, and I think it was common ground that all A, B, C, and D in para 14 would have to bite and apply, so it wasn't just one was enough. But he disagreed with our position in the High Court, because we were saying that because there was no conflict with the neighbourhood plan, you didn't even get into the nitty-gritty of paragraph 14. Because the Court of Appeal agreed with us on that, the Court of Appeal didn't need to go and look at para 14 in any more depth. But there was an interesting point, I think perhaps Ruchi, you want to deal with it, in the High Court that's left open, which might be something for future future debate on paragraph 14.
Yes, as John mentioned, so there's 4 limbs effectively to paragraph 14 that you have to satisfy before it's engaged. And Tim Mould in the High Court actually, while he agreed with us on how to approach paragraph 14, i.e. that you have to tick all 4 boxes, he spent some time looking at limb B, which is the question of whether, does the neighbourhood plan contain the policies and allocations to meet its identified housing requirement? And he spent quite a bit of time, we discussed this in court quite a lot, and he has a couple of paragraphs looking at this in his decision, where he takes the view that whether or not 14B is met, i.e., have you made provision for your housing requirement, you basically you sort of stop, that question is answered by looking at the facts at the time the neighbourhood development plan was made. So the fact that, 2 years on or less than 2 years on, the requirements had, the housing figures the numbers had completely changed, and the fact that the housing need is now identified was basically not being met at all was irrelevant. So you just don't consider that. Now, that debate was not restarted in the Court of Appeal for the reasons that John's given, but it's quite an important question as to how you really read 14B. Are you sort of stuck in time, or can you actually take into account the fact that things have changed so much materially on the ground that there's, the neighbourhood development plan simply doesn't really provide for its housing requirement?
Yeah, I agree, and I suspect what the Court of Appeal would probably like us to say is that this is not, the NPPF is not a statute, it's not a contract. You've got to apply it with common sense and try and achieve practical decision making on the ground. It seems to me if you were doing, perhaps with great respect as the High Court was suggesting, and pinning it down to a particular point in time, you're perhaps being a bit legalistic and ignoring the thrust and meaning of that paragraph, which is really, it seems to me, saying you should give weight, in particular weight, to a neighbourhood plan if it's up to date and if it's doing certain things. And if in a point in time, because the evidence has moved on, the neighbourhood plan is not doing things, it seems to me that's the kind of position as a matter of application where you wouldn't be relying on that paragraph. So, I mean, that's an interesting point in planning as to what extent we're talking about a bit of common sense and application, or getting tied up in the meaning and the tense and the drafting of a particular word in the NPPF. But having said that, Hopkins Homes is a good example where we spent 3 or 4 years talking about 2 words in the NPPF as a matter of construction. So who knows? But I think what we're saying is we sense a bit of change in perhaps in light of things like Hopkins Homes, which of course ironically at the end, and then they redrafted the NPPF, so we're back to square one. So we've got a number of questions coming in. We've got one from Max. Max Short sent us a couple, and Max, thank you for your questions. He says, is the emphasis on the word focused in the Court of Appeal judgment not in danger of being too legalistic by reading one word in isolation? How do you read policy 1 in the context of the neighbourhood plan as a whole, in particular paras 4.2 and 4.5? And Max, you've obviously done your homework and read some of the paragraphs around. Well, Max, the short answer is that I don't think the Court of Appeal didn't really just look at the word. We had made submissions about the context, including those paragraphs in the neighbourhood plan, and there were competing arguments from either side as to what that context may mean for the word focus. But I think what the Court of Appeal was saying was that you don't ignore that entirely, but really at the end of the day, just look at it as Asda, as the case about, so let's just be realistic and look at what focus means. And yes, you've got to look at the context to some extent, just as a sense check. But focus doesn't mean you can't have anything. I think that's what Lord Justice said. And once you appreciate that, it really is a matter of judgment in this case. Now, there may be other differently worded policies where it's quite clear what something means. It can only mean one thing, or there's a construction argument to be had. But this, I think, was not a case. So I think the Court of Appeal would say, and I'm not for obvious reasons going to disagree with the Court of Appeal, would say that it, far from being too legalistic, it was the right thing to take a common sense view, a textual analysis what focus meant and apply it with common sense.
Yeah, I agree with that. I think, in fact, the Court of Appeal judgment is basically doing everything it can to avoid being legalistic. And so it's basically saying, just like, forget about the legal interpretation side of things, and let's just sort of get on with it and look at how this officer's applied this sort of common sense word and whether he's applied it in a common sense manner. But just, Max, I think there's a second part to your question, or it's coming into questions really. And your second one says, where an officer does not set out an interpretation of a policy in a report, is it not appropriate to see how it has been applied to understand how it was interpreted? And actually, I mean, you've probably seen this in the judgment, but it's quite an interesting one, because that's sort of a lot of the debate in the Court of Appeal was around exactly that, where Lord Justice Singh effectively was pushing to the barrister for the Parish Council, saying, but where's the legal error? Because as far as I can see, the officer isn't interpreting policies anywhere. You know, he's just applying them. And the Parish Council was certainly saying to the judges that actually, well, let's look at how it's been applied. And if they applied it in X way, it must mean they interpreted it as Y, and therefore that was wrong. And the judges were not too impressed with that sort of approach. So I think basically, yeah, the judgment does everything possible to just move away from this super hypercritical, legal, lawyerly analysis of what is effectively and should be planning judgment.
Yeah, we might be doing ourselves out of a job here, Ruchi, so just to steady in what you're saying. Sue Chadwick, hello Sue, nice to hear from you again, has asked a question thanking us not for focusing on hillside, which we agree, and then saying making planning judgments is difficult enough. Do you think it will get easier or harder if the proposals in the Levelling Up Bill, dominance of national development policies, etc., become law? Well, I don't know whether it'll become easier or harder. I think it'll become more important than ever if those kind of revisions come forward to get a real handle on this kind of case law, which will be, I think, an application to those kind of statutory provisions and what they're asking decision makers to do. To understand, I mean, personally, I think from a legalistic point of view, it's far better, and this is not only for local authorities defending decisions, but also from applicants seeking to protect decisions they've got or seeking to formulate a proposal and get it through the planning system, is to frame matters in terms of planning judgments. It seems to me if you've done that properly, it insulates to some extent decisions from legal challenges, because if you get over that initial hurdle and decide it or apply in that way, when you get into if someone tries to challenge it, the court is much more likely to say, we're not interested. This is a judgment, and unless you can show us it's perverse or irrational, or this challenge isn't going any further. And I think that's really what the Court of Appeal is trying to do. But Sue, as you point out, when you've got these potentially statutory provisions emphasising the dominance of policies and the material considerations and so forth, and the NPPF, this distinction will become more important than ever to get a handle on and get your head around. Good, I think that's probably all we've got time for. The good news is that we're about to end and you can go off and enjoy your mornings. We have got the Cornerstone Planning Day next week, which I think a lot of you are coming to. There may still be some spaces left. We've got about 180 people coming next Monday to London for a nice bit of food and more debate. Ruchi and I will both be there along with other members of our planning team. So we hope to see many of you there. But for now, thank you very much for attending. We hope it's been useful for you. Any other questions, don't hesitate to try and contact us through our clerks, and we'll get back to you if we can. And we hope it's been a useful webinar for you. So thank you very much indeed.
Thank you.